Go ahead and get started here. I want to thank everyone for joining us. This is Advancing Your Case and Reputation Through Professionalism, hosted by our Workers' Comp section of the Volusia County Bar Association. And I'd like to pass it over to Clay Meek. He is a past president of the Volusia County Bar and is currently the Workers' Comp section chair as well. So, Clay, over to you.
Thanks so much, Sarah. And thank you everybody for attending today. And hopefully we'll do this more than once, but I want to thank all the other speakers for agreeing to participate here today and spend their time not only in presenting here today, but in the preparation that I know it took to get ready to do this today. I greatly appreciate that personally and on behalf of the Workers' Comp session and the Volusia Bar. Before we get into sort of the details of the speakers and the outline of the topics we wanted to discuss, I wanted to start off by just sort of refining and defining what it is we're talking about here today, because Florida is somewhat unique, but seems to be sort of the trend when it comes to ethics and professionalism. Those frequently get considered as one and the same or lumped together, but technically they are two different things. Ethics within the state of Florida and the rules that we have to follow under the professionalism guidelines of professional conduct in Florida are the minimum standard that we as lawyers are supposed to be able to meet. It establishes a threshold. It does not establish a ceiling or aspirational goal for the most part. On the flip side, the professionalism is also dealt with in Florida Bar. It is within the same house, so to speak. But professionalism is defined by the Florida Bar as something that is pursuing the highest ideals and tenets of the legal profession. And they break it down into four different categories of being of good character, being competent, being committed, and being civil. And a lot of the things you're going to hear today are various topics or points within those four general tenets, including integrity, fairness, timeliness, preparing clients for witnesses and hearings and those types of things. But I wanted to start with discussing the difference between ethics and professionalism, because I do think, at least personally, those two terms frequently get commingled in my mind, and it's easy to fall, for me as a lawyer, into the trap of thinking if I'm meeting the basic rules of ethical requirements, I've done all I need to do. I don't need to worry about anything else. And today is really about reminding ourselves and everyone else of the benefits of trying to aspire to do as much as you can above those minimum thresholds. And the other difference, or a difference, between this presentation and the way the Florida Bar sometimes presents it is, and I'm in no way criticizing the Florida Bar whatsoever or their outlook, but there's been sort of a movement over the past few years within the Florida Bar to move the aspirational goals of professionalism into more of a quasi-requirements type of thing, that failing to be sufficiently professional, even though it doesn't meet a strict ethical rule, could potentially run you afoul of the Florida Bar. And the goal of today's presentation is not to tell people about the stick or make this a stick or else type of presentation, but the speakers and I wanted to sort of go over some points and thoughts about why you shouldn't strive to be professional just so that you don't run foul of the Florida Bar. You should strive to be as professional as possible, because it will help your personal reputation. And more importantly, it will help you get the best possible outcome for your client by trying to strive to be as professional as possible. And so I wanted to give a context before we all started speaking of what today's presentation is about and oriented towards. Having done that, I know I can see many of the names on here. I'm familiar with many of the people, and I think many of the people are familiar with me. But I will just briefly review sort of who I am and who our other speakers are before we get into the individual topics. For those of you who don't know me, I've been practicing workers' compensation in Florida and Volusia County since approximately 1995. I hope to someday be able to stop practicing and to do it well, but for now, I've just been practicing during that time period. In addition to workers' compensation, I do a few other other areas of practice of law, none of which are overly germane here today, other than I occasionally get to sit as a hearing officer in very, very limited matters, none of which approach the complexity of a workers' compensation hearing, but it is another area of my practice. Judge Anderson, joining us here today, is an extremely distinguished judge. He's been a judge of compensation claims in what is now the Orlando district, where he currently sits, but he was previously the judge of compensation claims for Daytona Beach. And prior to that was a judge of compensation claims in Jacksonville. Judge Anderson has done almost everything you can in the field of workers' compensation. He has been an advocate on behalf of clients. He has been a mediator. He has served as an attorney in the workers' compensation unit at the First District Court of Appeals, and obviously has been a judge for a number of years. I've had the privilege of knowing him a long time. And for those of you that never met him prior to him sitting as an Orlando judge, I can tell you in every role I have ever met him and in every judicial seat I have ever encountered him, his current extremely professional demeanor and presentation has been consistent throughout the time I've ever known him. So I'm very, very happy that he agreed to be part of today's panel. Mr. Romanek is actually the longest continuously board certified workers' compensation attorney in Volusia County. He graduated college from the University of Florida and law school from the University of Florida. I like him despite both of those things. I think he's a great person and extremely talented lawyer. And he's been practicing in Volusia County and the overall state of Florida since 1995 in both workers' compensation and numerous other employment-related fields. He's got a great breadth of knowledge, backgrounds, and just practical insight into cases. I was thrilled when he agreed to be a part of this presentation and panel. Jesse Rowe graduated in 2007 from the University of Central Florida. Thereafter attended Florida A&M while at night, while working full-time during the day. I've got great respect for that 100%. He graduated in 2014 cum laude, despite working throughout the time he was going through law school. And he then transitioned into working as claimant's attorney. He had been a claimant's attorney's practice paralegal prior to that time. And he's been at the Morgan & Morgan Daytona Beach office since 2018, practicing in workers' compensation. Mr. Rowe became board certified in 2024, extremely quick to get board certification, which is a testament to both his knowledge and the volume of cases he's able to handle competently. I've known him, I think, since he came to Daytona Beach as a workers' compensation attorney and joined Morgan & Morgan in Daytona Beach. I've had the privilege and ire of litigating cases against both him and Mr. Romanek, and each of them are extremely good at what they do, and they do it in an extremely professional manner. Without further ado, and any of them, if I've left out anything, certainly feel free to mention any qualifications. And if anyone in the audience has any questions about any of our backgrounds and experience, there will be a question and answer session towards the end of the presentation. And I will be happy to do so, and I'm sure all the others would be happy to do so as well. Before I get into the topics, just a couple of other things I did want to share, which is we've broken it out into four different sort of areas of professionalism that we felt would be good areas to talk about here today. I did want to let everyone know that as the organizer or sort of the person that got the ball rolling for this, I did share some of my thoughts on each topic with all of the presenters. So even if I am not particularly talking on a topic, I might have shared an idea about that topic that the speakers may or may not wish to use when it's their time to speak. I say that only because if you hear something come out of another speaker's mouth and I'm not part of that panel and you think, where did that come from? I don't think that's on base. That came from me. I seeded the fields in everyone's presentation with ideas that may be half-baked. So if anyone has any concerns or feels that a comment was not well placed, that is not the speaker's fault. That is my fault. And lastly, I do feel extremely good about the presenters have here today and our topics. And I am so confident in that if anyone that joins us here today is in any way dissatisfied or does not feel that their time was well spent attending today's event, all you have to do is email me and I will personally refund you 100% of your registration fee for today's event. That is how confident I am in our presentation here today. That being said, Judge Anderson and I are going to lead off discussing professionalism in motion practice. And in accord with sort of the idea of professionalism, one rule I, as a practitioner, always like to follow is you defer to the judge as to who goes first and in what order you should proceed. So, Your Honor, would you like to lead off the discussion in this particular topic, or if you'd like me to, I'm happy to as well, sir.
Sure. Well, first thing I'd like to do is thank you, Mr. Meek, for taking the time to put this presentation together and for inviting me to participate. It's great to see everyone here. A lot of the names I see on the Zoom screen are not workers' comp lawyers. So, we get a little bit enclosed in our specialty, and we don't see that many attorneys who are not in the workers' comp field. But professionalism is something that is universal. It doesn't matter what specialty you're in, what line of practice you're doing. Professionalism is still professionalism. And so I'll just start by saying that, and I'll let you kick off the specifics, Mr. Meek.
Oh, thank you, Your Honor. And well said. And I think a lot of the things that we'll have to talk here today transcend specific practice areas. I think these are ways people should behave no matter what type of proceeding they're in. And to that end, one of the things that is a personal pet peeve, maybe it's because of my age, maybe it's because of when I came up in the legal profession, but very frequently I see people at motion hearings or other legal events, and by people I mean attorneys, pro se sometimes, but you can forgive that. Attorneys, when you show up for something that is a legal proceeding, you need to dress professionally, and you need to act professionally. I understand, and I've heard from many attorneys that maybe are new to the legal field, that whether they have a tie on or a coat on does not affect their mental process one way or the other. And I always like to respond to them that, part of presenting as an attorney is showing that you're there to present as an attorney. And particularly in the field of workers' compensation, but I think it also extends to other practice areas. One thing that I think attorneys frequently encounter, which can be bothersome to their practice of law, is that when it gets down to critical decisions to be made in a case, that you need to discuss with your client and come up with an agreed course of action. More and more, I think many attorneys are encountering Cousin Eddie, who has been giving advice to your client, and Cousin Eddie thinks you should go this way in the case, regardless of not having a legal degree, regardless of not having legal experience. And I think that the more attorneys fail to dress in front of their clients in a way that is different from Cousin Eddie, and fail to act in a way in front of their clients that is different from Cousin Eddie, the easier it is for that client to start comparing what you have to say to Cousin Eddie. Because we can't walk around with our legal degrees hanging off of our sleeves. What we can do is walk around and conduct ourselves with a coat, with a tie, if you're a gentleman appearing before the court, and if you're not, if you're a woman appearing before a court or in motion practice, dress appropriately as well. And as far as acting professionally, anecdotally, I will not share any person's names, but I was recently at a hearing where I was wearing one of my other hats, where I'm not an advocate and I wasn't a decision maker, but an attorney got up to make a presentation in that non-workers' compensation proceeding. That attorney presented a really good argument, outlined facts really well, and a decision maker leaned over to me to discuss it, which was appropriate in the context. And the only thing on that decision maker's mind was the fact that the lawyer in front of the group presenting was chewing gum the entire time the lawyer was presenting. And so part of acting professionally is showing up. Don't chew gum. Don't have something in your mouth. Act like you're showing up to engage people and, be not a TV lawyer, but be an old classical movie lawyer where you're putting on all the bells and whistles to have that polish. And that said, I don't know if Your Honor has any thoughts on that or
Yeah, I would just say that one of the challenges we have now is a lot of things are virtual, like this CLE today. And I always like to remind attorneys when they're appearing for workers' comp matters by Zoom is that it's not really any different than if you were sitting here with opposing counsel and the judge in chambers. It's the same thing. And so uh, unfortunately, I've had cases where the attorney is in a t-shirt or whatever, and because it's Zoom, the assumption, I guess, is that it's okay, and always remind them that it's not. And the reason it's not is not because there's something wrong with wearing a t-shirt, it's that you're not showing respect for the process. And you're a professional. You went to school a long time. You worked very hard to become an attorney, and then you are involved in a process that involves people's rights and obligations, and it's very serious business. And so when you're doing that, you want your client, you want opposing counsel, and you want the opposing party to understand that you're there as a professional and you're dressed appropriately. So that applies, in my view, whether you're doing it by Zoom or whether you're doing it in person.
excellent points. Did you want to go with any other, or would you like me to throw a new one out?
Go ahead.
Okay. Being mindful of the time, one thing I think some attorneys, when you get in an adversarial situation, you can overlook it sometimes, but it will 100% hurt your case, is do not object to motions that the judge is going to grant. Do not fight stuff that when this motion gets in front of the judge is going to say yes. Do not make the other side go through the motions of making the motion, setting it, getting in front of the judge, or getting it heard on a non-hearing basis, if it is something that the judge is routinely going to grant, if there's no question about it. And that can sometimes be simple discovery matters. It can also be bigger things. And my poster child for this, attempting to keep it brief, is a few years ago now. My father passed away on, we'll just say it was the 5th of the month. And I had a final hearing scheduled before a judge of compensation claims on the 12th, a week later. My father passed away in circumstances where an autopsy was going to be required. So at that moment, I didn't know for sure if the funeral was going to be the 12th or the 13th. It was going to be one or the other, either the day of the final hearing or the day immediately after the final hearing. I promptly contacted opposing counsel on that particular case and relayed the circumstances and said I was going to file a motion to reschedule the final hearing. That attorney said he objected to that 100%. And it was annoying for a moment, but it was a wonderful gift from the other attorney to me, because how do you think that judge felt when that motion landed on the judge's desk in those circumstances? It was one of the quickest continuances I've ever gotten in my life. And that attorney had to then deal with the unspoken ramifications of, you're the person that thought this was an appropriate circumstance. And that's an extreme circumstance, obviously, something that doesn't come up all the time. But to me, it's a good example. If the judge is going to grant it and you're fighting tooth and nail, or even a token fight, making the judge decide on a contested matter rather than an unopposed motion, it's going to reflect more upon you as the person objecting than it does on the person having to make the motion. And I don't know if Your Honor has any thoughts on that.
And I'll just add to that one of the issues that we see quite often in our practice are motions that get filed at the last minute. Sometimes that's unavoidable, but if it's not unavoidable, to me, it's clearly not professional to wait until the last minute to file your motion for whatever it may be. We get, for example, sometimes motions to continue a final hearing that get filed within, a day or two before the final hearing, and it's based on something that was known to counsel well before that time. And so it's not an ethical violation to file your motion at the last minute, but it certainly is unprofessional if you could have filed it earlier to give the parties and the judge a chance to decide with a little more time to spare.
Yeah, and along those lines, and I'm not speaking to any particular case or any particular judge. In my experience, if I file that motion 60 or 90 days ahead of that final hearing, I don't think I've ever had one of them denied. If I file it less than 14 days before that final hearing, I think at best I'm going to have a coin toss of whether it gets granted or not. And again, if you have an issue and you need to be at a place at a certain time, it's in your client's best interest and it's your interest in advancing the case to make sure that you can do that without worrying, how am I going to attend two things at once? So the timeliness of the motions is certainly extremely important in getting that good outcome for your client and not stressing about other things rather than focusing on the case.
Absolutely.
Your Honor, was there anything else you wanted to bring up on this topic? I'm trying to be sensitive to my timeline, and I apologize. I ran a little bit long in the opening, so I was going to transition unless there was something else you wanted to make sure we said here.
I think it's fine. I think the important thing to remember is it sounds cliche, but it's the golden rule. Treat others the way you want to be treated. And if you do that, most of the time you're going to be good. So I'll let you go from there.
Excellent words. So our next topic is going to be professionalism in depositions, and Mr. Rowe and I will be discussing that. Jesse, did you want to lead off with this, or would you like me to? Whichever you prefer, sir.
Sure, go ahead, Clay.
Okay. Sure. I think a great place to start in depositions is, and I'll say this also as an aside, everything you're going to hear today, whether I speak about it or not, I will fully admit at some point in my career, I think I've been guilty of every violation. This is about learning from past mistakes and coming to a point of being better as a group. So anything I say, I admit I've been guilty at some point. That being said, I can't stress enough the importance in cooperating and scheduling depositions as to how that helps your case. And I know personally, sometimes it gets extremely frustrating when you feel like you're not getting reciprocal cooperation. They're happy to schedule the depositions that they want to have happen, but they don't want to schedule your depositions. And I would encourage everybody that schedule the depositions the other side wants. Especially if it's pre-mediation, but even if it's mediation has happened and you're getting ready for trial, if they need a deposition prior to mediation, it's in your client's best interest for them to get that deposition so that they have the information they need to be able to advise their client on, here's a critical fact in the case. Here's how the testimony played out. Here's how it affects the value of the case. Most of our cases, I think in every realm of practice, not just workers' comp, the overwhelming majority end in settlement. It's in your best interest, it's in your client's best interest to cooperate with setting depots so that the other side has whatever information they need in order to make an informed decision at mediation and be able to reach an agreement at mediation. And if it's for final hearing, if you don't cooperate in setting those depositions, you're handing a continuance to the other side. Very rarely is the stonewall of coordinating depositions going to result in a positive outcome for you. It's only going to end in a various shades of gray of a negative for you.
I agree. I think that also what we see a lot in any practice area is the timing of setting the deposition. So oftentimes one side wants their deposition to occur before the other so they can have the benefit of hearing that other side before they prepare their witness. And I've seen it before where, hey, I'd like to take your client's deposition, and they'll say, well, we need to take your client's deposition first, and then we'll let you, right? And that can be very, first of all, it's very unprofessional, but it could be borderline unethical. So I just wanted to echo that as well.
I 100% agree with that thought. And it is something, unfortunately, that you do frequently see, that you attempt to set a depo and the other side says, fine, as long as you meet all these conditions. And, in my experience, there's nothing in the rules, there's nothing in the statute that says there's conditions to it unless a judge sets those conditions. Did you want to lead with any other topics, Jesse?
I wanted to talk about preparation for deposition, specifically preparing your witness or your client for the deposition. You know, if you're on a plaintiff or claimant side, especially, I think this is important because you're dealing with someone who this might be their very first time in any kind of a legal process whatsoever. They don't know what to expect. Oftentimes, your client may not even know the difference between a deposition and a mediation. They all end in TION, and they're not really sure what it is. And I think it's important to explain to them what a deposition is, why are you having a deposition, and what to expect in the deposition. And that's not just the questions, but what are you expected to wear? Okay. How long am I expected to be there? Should I set aside an hour, 2 hours, all day? So I think a lot of that that speaks to your ethical obligation to your client, but also a degree of professionalism to your client and to opposing counsel. If we can if you have a prepared witness, the deposition can always run much smoother, usually much quicker, and certainly much more efficient. The preparation also should include how to answer questions properly. How should you answer this so that you're not coming across argumentative or you're not giving the court reporter a hard time by talking over each other? All those things. And then lastly about preparation is give them time. 15 minutes before the deposition starts is not proper preparation. Whether you're the plaintiff, claimant, or not, anybody's going to be a little bit nervous to have their deposition taken. They're in the hot seat, they're under oath. So 15 minutes beforehand, their mind is swirling and they're not really listening to what you're saying for your preparation. I always prefer to do a preparation at minimum several days beforehand, or perhaps even a week beforehand, to give the witness time to digest the information. And you never know when they take a couple of days to think about something. Oh, you know what? I just remembered that. I need to make sure that I mention that. So try to get your preparations done in advance. You can instruct your staff to look ahead on your calendar. Hey, look at next week. If I have any depositions, set the prep for this week or at least a couple of days beforehand.
Excellent ideas and thoughts. And one thing I would say along those same lines, and if I didn't mention it earlier, for anyone that's not familiar, I personally, I do both defense work and claimant work, although the majority of my practice is defense work, and that's probably, if you've encountered me in workers' comp, how you've encountered me. But on both sides of the work, I think one thing that I frequently see get left out in the depo preparation that I always try to include when I'm speaking with my client on either side is, let me do the objecting. Your job is not to object. There may be a lot of questions the other attorney asks that seem like it has nothing to do with this case, and there's no reason for you to answer it. You don't have a law degree. You've never tried a case. I know when it's supposed to be objected to or not. So let me do that. And I also try to always stress to my witnesses that you need to avoid getting into any kind of conflict with the other attorney. This is not about you debating. This is not about you arguing. This is just about answering the questions. If there's something that needs to be objected to, I'll make the objection. And one thing I frequently see as a mistake that occurs from both defense attorneys and plaintiffs' attorneys is maybe that instruction hasn't been given and the witness starts objecting, and instead of the attorney jumping in and saying, hey, I've got this, you just worry about the questions, I'll frequently see younger or less experienced attorneys start echoing objections that aren't even legal objections, but they somehow feel they're obligated to back their client up. And in my experience, it always ends up in a more contentious, a longer, and a more draining deposition for both sides than when I frequently see more experienced attorneys will shut that down very quickly and openly in deposition say, I'll object if it needs to be, you just answer the question.
Speaking of objections, there actually was a recent amendment to the civil rules of procedure in Florida. Just really showing that the intent of making objections in depositions need to be specific. You don't need speaking objections. You don't need to, again, you're not arguing your case. You're not saying, this shouldn't be discussed because da, da, da. Just say objection, state the reason, state the basis for the objection and the reasoning, and then that's it. You don't get to instruct your client not to answer just because you don't like the question or because you are objecting to it. You only instruct your client not to answer if it's going to violate their Fifth Amendment privilege or if it's some other type of privilege like attorney-client privilege. So just state the objection in a very clear and concise manner that puts the other side on notice of what your objection is and why. Get it noted on the record, and then move on. Let them continue with the questions. The attorneys don't need to be arguing that, especially in front of the witness, as to what the objection is and whether you're right or you're wrong. I'm allowed to ask this question. No, you're not. That's something you take in front of the judge. Just get your objection on the record, have it noted enough so that the other side knows what your objection is, and then keep it moving.
Very good point. Was there anything else you wanted to make sure you covered in this section, Jesse, before we move on to the next one?
Nope, all good.
Okay. In that case, I will bow out. I'm not going to mess my computer up by trying to mute myself, but I will shut my mouth and let Mr. Romanek and Mr. Rowe discuss professionalism in the mediation process. And then I'll just jump back in when we get close to that 10-minute mark, guys.
Thanks, Clay.
Well, I will say real quick, just to start that off, in mediation, sort of echoing the sentiment of the preparation for depositions, I think it's very important to get your client prepared well in advance for what to expect with mediation. Same thing as I said before. What is expected of them? Who's going to be doing the talking? Why are we even having a mediation? What are the possible outcomes of your mediation? How long is it going to be? All of those things play a key role in the success of the outcome of the mediation. If you have a well-prepared client, somebody going in there that has no idea, again, they're nervous, they're not really sure a lot of times what's to be expected. A good preparation, again, I prefer to do several days ahead of time, if not a week ahead of time, for time to digest. And also know what the issues are. Because if you talk to your client 15 minutes before the mediation starts, you might find out that there's no issues. So why do we even have a mediation? You may want to give it some time to determine what are the issues that are being presented and what do we want to do. Give you and your client time to get on the same page. So I'd say the same rules for deposition preparation apply to mediation preparation.
One thought I have unique to the comp process that lawyers who aren't regularly involved in is that we have the affirmative obligation to go pull child support information and alimony arrears. And in my experience, and I bet the rest of you who regularly do this have similar experience, 90% of my clients say that's wrong, and 90% of my clients a month or two later ultimately concede, okay, that's right. And the sooner you can get past that, the better. And in a similar vein, one thing that we had all discussed and found very important is forewarning people about important, unexpected things is very helpful. Surprises at mediation don't help. They tend to derail things. They tend to put people on the defensive. And just as the child support issue, if there are other smoking guns like surveillance tape that's going to be determinative, again, sometimes there's some benefit in sandbagging those things, but I think genuinely and generally, more often than not, sharing in advance is much more likely to lead to some type of consensus than waiting till last minute.
Yeah, I agree with that. If you've got something that's, if you have an elephant in the room, bring it up beforehand so that you have an opportunity before you get into mediation to talk about it and see how you're going to deal with it. There's a couple other things too. I think that avoiding commenting negatively about the other side is important in your professionalism in a mediation. You can make legal arguments, but you don't need to undermine the person, especially if you're dealing with, let's say, a misrepresentation issue or an issue where you think there's somebody that may not be candid and truthful, you don't need to attack that person individually. You can attack the substance of what their testimony might be. That keeps it much more professional, and allows you to move the mediation along, much more efficiently as well. Also, this isn't a requirement. This is kind of the whole idea about ethics versus professionalism. Professionalism, excuse me. Ethics is the bottom, is the floor. Professionalism is the ceiling that we're striving for. Send a demand to your opposing counsel or just an idea ahead of time for mediation. If you're on the plaintiff or claimant side, sometimes sending a settlement, if you're going to discuss settlement, send them a settlement demand a couple days beforehand so they have time to talk to their client and gather proper authority so you can have a good outcome and a good productive conversation in your mediation. Or it could be the opposite. Ahead of time, you can say, look, we are not interested in discussing settlement. We're just interested in discussing XYZ in this case, or specific issues, so that they can prepare their client for that as well. Again, ethically, are you required to do that? No, you don't have to do that ahead of time, but professionally, it can be a good thing to give them a heads up beforehand, at least a few days, so everybody can be prepared for what's going to happen during mediation.
And I think also it's important to look at the timing and sequencing of how these things unfold. Obviously, the longer cases drag on, the more expensive they become and the more difficult it becomes to resolve them on the back end. And I think with that in mind, like Jesse said, about forewarning people what you're really looking for and where the issues really are or what the goals really are, make it much more likely to achieve those goals without it being a last minute scramble and an impossible to resolve issue.
I don't have anything else to add on that. Thank you.
I don't either. I think we're ready for next up, Mr. Meek.
All right. Then we'll have Judge Anderson and Mr. Romanek will tell us about professionalism at the final hearing.
And Judge Anderson, if it pleases the court, I have a quick anecdote I think I'd like to share that was very illustrative on this.
By all means.
Very early in my career, I was invited to, and it's kind of disappointing. Maybe there are more of these, and I've just like not been invited to as many of the parties. But we had an interesting event where the Orange County Bar Association lined up a mixed social that invited a bunch of doctors and accountants and lawyers with the idea of just like cross-pollinate some and get to know some other professionals. And as we tend to do, you're more gravitated to talk to the people you already know. And I happened to be chatting with Bill Rogner at this event, and a gentleman who we later found out was an accountant came up and introduced himself and first turned to Bill and said, "So what do you do?" And Bill responded, "Well, it depends on what my family's in the mood for and what the weather's like. Sometimes I kayak, sometimes I bicycle." And obviously that wasn't the thrust of the question, but it was very illustrative. And once we were back only in each other's earshot again, Bill pulled me aside and said, "Hey, I like that you get it, that this is not your case, this is your client's case, and keep that in mind. Like the scariest lawyers in the world are the lawyers that if you take away their bar card, you take away their personality." And that really resonated with me. And I think that's one of the main pillars of what I always try and think about in a hearing. We're there to be brutally good. We're there to help our clients, but we're not there to fight with our opponents, right? We're there to try and secure things for our clients or prevent the client from getting what they're seeking or whatever our professional goal is. But remember, it's not your fight. I think that's an overall professional framing of keep that in mind when you walk into trial. You're fighting for your client. You're not fighting amongst yourselves.
I wholeheartedly endorse that view of the process. And I always like to tell audiences when I speak about this, it's that in workers' comp, we don't have juries. In workers' comp, we've got a judge and attorneys and parties. And so you can leave the drama at home. It's not professional to come in and engage in ad hominem attacks on opposing counsel or the opposing party, or to behave in a way that's unbecoming the process. As I said earlier, it's about respecting the process as much as anything else. And so when you get to a final hearing in workers' comp or a trial or a bench trial or whatever you may be doing in your practice, just remember that we're not there to cast aspersions on opposing counsel. And while we may be advocating our client's position, we're not trying to rub the other party's face into the mud, as it were.
I agree. And another thing I think that's very important to keep in mind is the regular formalities that are a little more difficult now that commonly we're living in the Zoom world, but things that we all learned as young lawyers to remember to emphasize, like asking to approach the bench, may I call the next witness, and remembering that the judge is in control of the show, providing appropriate deference, I think sets the right tone for everyone participating, including the witnesses and the lawyers.
One of the things that I see, unfortunately, is when we're having a final hearing in a workers' comp case, is that some attorneys will lapse into deposition mode and sort of forgetting that we're in a trial and the judge is there, and so there's a testimony going on, and suddenly the attorney just sort of pipes up with a kind of a vague objection as if it were only for the record and not waiting for the judge to make a ruling on that objection. The other thing about depositions in workers' comp is that we have a lot of them, and they come into the record and the judge reviews those depositions. So we were talking earlier about your professionalism in doing depositions. Remember, what you say on the record in that deposition, if it goes into evidence at the trial, is going to be considered by the judge as well. So if you acted inappropriately or basically, made a big scene in a deposition for whatever reason, you may be, auditioning for the judge to sort of discount what you say. So I would say that if you're going to be professional, it goes from day one, from the day you start the case until the last day of the case. And there are no periods in between where you can say, well, I can just do what I want to do and nobody's going to care.
Hey, and bear in mind, don't criticize the judge. I had a somewhat astonishing circumstance once where there was an objection to an independent medical examiner's testimony coming in, and the objection was that it was hearsay, and predominantly what the independent medical examiner relied upon was the prior treating doctor's records. And my succinct and polite response was 9704. And the defense lawyer echoed the same objection, and the judge said, "Do you have anything more to say?" And I said 9704, and the judge barked at me and said, 97 what? And I realized, oh, the judge doesn't have any idea where chapter 90 of the evidence code is. And I politely excused myself and went and retrieved the code and shared, and that was that. And it was one of those astonishing moments. But we're not all perfect. We don't all know everything. Commonly the judges know more than we do, but every once in a while they don't. And just keep that in mind. And for what it's worth, of course, it wasn't Judge Anderson who pulled that one on me, but keep in mind, but keep in mind, it's not, the courtroom is not the place to argue with the judge about who's right. The courtroom is the place to politely and succinctly make your argument, preserve the record, and move on. There's no point in fighting with the judge. That doesn't tend to get you anywhere, and it doesn't provide the correct and due respect to those who are participating and the lay people who are participating.
I think most judges will agree with me when I say that after I've overruled an objection at trial, the judges want you to move on. They don't want you to continue to argue your objection after a ruling has been made.
I wholly agree. One other thing, I appreciated this, and Judge Anderson gave me a nice compliment, but I must admit it wasn't engineered this way, but it's something to consider. Judge Anderson pointed out when we were talking that he thought it was interesting when I appeared for hearings that I typically appear like I'm standing at a pulpit. And the truth is, it wasn't intended necessarily to be professional. It was intended to make my herniated L5S1 disc more comfortable by standing than sitting. But for what it's worth, for all of you out there, at least one judge finds it to be perhaps more reverent to be standing for presentation. And just for what it's worth, it's interesting. I wouldn't have known that would have made a difference, but it did in Judge Anderson's eyes, and I just thought I'd pass that along as insider information from those of you who might benefit from it.
Well, Matt, it probably made a difference in you and you didn't realize it. You're standing at the pulpit. You probably acted as if you were attending live without even realizing it,
It may well help. It's interesting.
Yeah, I may have called it a lectern and not a pulpit because I don't think you were preaching, but either way, I thought it was good. And uh, it's not so much the act of standing, but I did think that it was something that showed that you were very engaged in the process, and I appreciated that.
It is. It's interesting, and it's also fascinating. It makes me feel old and dated, but the fact that I've actually now completed several trials by Zoom in my own office still seems somewhat mind-boggling to me. But it's really just like the same rules about remote mediations and depositions. A remote trial is still a trial. It's important, and I hope that people continue to give it the respect they desire. And those of us who are used to driving tons and tons of miles all over to do our practice that now don't have to. For those of you who haven't had the burden of doing the extensive traveling, really do appreciate and benefit from the efficiency of our ability to appear remotely and more efficiently these days. It's really a blessing.
And one more thing I'd like to add to the discussion about professionalism and final hearings is that, make sure you do take the time, and we touched on this earlier, to prep your clients and tell your clients what it's about, because I have unfortunately seen cases where the attorney for the claimant comes in with his client. He hasn't really discussed it. The client doesn't know the difference, as we discussed before, between a deposition, a mediation, and a final hearing. Make sure your client understands that this is a trial, and he needs to dress appropriately to the extent that he or she can, and behave appropriately as well. It's not an informal proceeding.
Was there anything else, Your Honor or Matt wanted to add on this topic?
I think we've covered it. Thanks.
Okay. Well, in that case, I just wanted to open it up. Is there anything that any of the three speakers, well, before I do that, if there's anybody in the audience that has any questions, either of the group or any individual in the group, please feel free to unmute yourself, wave your hand, or either type that in the chat and Sarah can let us know when that question pops up. But in the interim, while anybody is thinking if they have any questions, if there's anything that any of the three panelists would like to add, either to something they've already discussed, just to reemphasize that, or maybe on a topic that they didn't get to speak on, if there's something you wanted to address, I certainly wanted to leave the floor open for any of the three of you to do that.
I'd like to add that I think it's very professional for people who see unprofessionalism or unethical behavior to confront it, perhaps talk to that person, offer maybe some mentoring to them. They may not realize that what they're doing is unprofessional or unethical. And it may be the way they were trained, or they may work in a practice where they don't have other lawyers or people around them to learn better. So take it upon yourself to, maybe offer some mentorship to that person or some guidance, or have them attend the CLE.
That's a great point. And along those lines, something that I have found more effective that I've started using later in my career is when I encounter that situation. Many times there's resistance to pointing out to someone, hey, I think what you just did is not the way you should be doing that. A way to overcome that resistance I've found is prefacing it with the phrase of, I know you're better than what you just exhibited. Telling the person that I know this was not your best moment. I know I've had bad moments. I have found gets a much more receptive audience. Usually not at that moment, because it's the heat of the moment, but on reflection, I think a lot of people are encouraged at the thought of improving themselves rather than viewing it as criticism. You did something bad. You putting it in the phrase of, this is not your typical standard, and just letting you know that I've gotten a lot more benefit or improvement in interactions. I don't know anybody else's thoughts on that.
I totally agree with that. And, it's the old saying about you catch more flies with honey than with vinegar. If you're polite and bring up these kinds of issues in the appropriate way, you're going to get a better response. And I've seen cases where it's happened both ways. I've seen cases where opposing counsel outside of the hearing will take the other attorney to task over some inappropriate behavior in the positive way, Mr. Meek, that you just discussed it. And I've also seen it the other way. And believe me, that makes an impression on the judge who's hearing your case, that case and the next case and the next case after that.
And Matt, I hope you don't mind me sharing this. If you can chastise me later. But one thing I would encourage, I actually stole this from Matt Romanek when I learned it from him long ago, that I would encourage everybody to employ when they're doing any kind of a final hearing, whether it's workers' comp, any proceeding whatsoever. One of the most professional gestures I ever received was at the end of the final hearing. Matt would make it a point to come over and shake his opponent's hand, which obviously in that case was me. And I found that to be just a wonderful reminder of the fact that be an advocate in the proceeding, but understand that's not who you are outside of the proceeding, and that you're going to encounter this person in the future. And don't lose your humanity over trying to win a case. But I would just encourage everyone to adopt that, because that was one of the best gestures I ever received many, many, many years ago. And again, Matt, I apologize if it bothered you at all that I pointed that out, but it was just a great thing.
I appreciate it, and it reminds me of one of my favorite anecdotes that one day midweek I got a call from Larry Feinstein, who said, "Hey, I just looked at my calendar and I noticed that we have a mediation at Judge Anderson's office next Monday at 10, and I was wondering if right after we stop pretending to hate each other, you'd join me for lunch at Sapporo." And I thought, like, it's good, and it's just like it's a good illustrator of just like, it's really farcical when people do pretend to be awful and hateful and spiteful, and there's just really no place for it at all.
Yeah. And I think no matter what your practice area is, I encourage people to remember that today's opponent might be the fee expert you need 2 years from now. They also, I've practiced long enough, and I think anybody else on this panel has practiced long enough, that today's opponent may be the judge you're in front of 3 years from now. So think about how you're treating that other person, because I think whether you act extremely professional or extremely unprofessional, both of those things are going to be burned in a person's memory. It's not going to be something that they forget 2 years from now, 5 years from now, 10 years from now. Sarah, were there any other questions or comments from the audience?
I don't see any questions in the chat as of now. I did post the CLE information in the chat, and I'll also send it out to everyone who registered in an email once I get the recording posted. So if you do have questions, we still have a couple minutes left if you want to type them in the chat. But be sure to self-submit for CLE. You can claim this as 1 hour professionalism or 1 hour general.
I want to add one more thing, and that is, if you're not already involved, find your inn of court in your practice area and in your, where you live. The inn of court is a great experience. Judge Anderson is our current president of our workers' comp Orlando inn of court. He can tell you the same thing. It's been a great experience. It's been great for mentoring. It's been great for discussing topics like this and really learning, talking to people from other sides and different anecdotes that you can come across. It's an excellent experience. And also that not only just learning how to be a little more professional, but I think just being involved in that, again, just shows your level of involvement and dedication to your practice. So I highly encourage getting involved in that if you can.
Yeah, I would second that.
It is. It's a great experience.
And just as to dovetail with that, I would say, workers' comp certainly is its own practice area. There is a lot of carryover into other practice areas. And I would encourage everybody to consider not just the workers' comp inns of courts to our west or our north, but there's also a general practice inn of court here in Volusia County. And I've gotten lots of pointers and feedbacks from, someone that maybe practices family law, which is also bench trials. And just you can learn how other practice areas deal with specific issues can sometimes be helpful. But whatever you join, I think, in also the Volusia County Bar Association, the more connected you are with associations of other lawyers, the more you see them in a social setting, the easier it is to remember that we're all people and we do not have to be antagonistic in order to advance our cases. And then finally, along those same lines, giving everybody a last possible minute to get in any questions they might have. I not only encourage, but request, if anybody has any ideas, any suggestions, any desired topics for the Volusia County Workers' Comp section, I am absolutely receptive to it at any time. Please email me, please call me. To the extent you already don't know it, my email is extremely simple. It is just my name, claymeek@yahoo.com. There's no extra letters, there's no extra numbers. And I would love to have in other practice areas. You don't have to pay an extra fee to be in the workers' comp section of the Volusia County Bar Association. You just have to say, hey, I'm interested in being in that section. And I would be happy to put something on about, as Matt discussed, the overlap between workers' comp and family law. We've got child support issues, or commonalities between presenting a final hearing in front of a judge of compensation claims or performing a bench trial in circuit court or county court. There's some overlaps there. I'd love to have any suggestions, requests, or pointers from anybody as far as future meetings, both topics, formats. Let me know if you like Zoom. Let me know if you hate Zoom. Let me know if you like live. Let me know if you hate live. I'd really like to adapt it to the membership to make it more available to everyone. And other than that, any other final comments by any of the presenters? Before I say that, I greatly thank all three of you again very, very much for being a part of this.
Thanks for
Well,
having us.
I
Thanks
just
for
like
having
to
us.
thank you for having